Basically, GLAD-2 allows a judge to use their judicial discretion to determine a fit and appropriate sentence. That doesn't mean the person will not go to jail. What it means is the judge takes into consideration the circumstances that brought the offender, the Aboriginal offender, before the court. And looking at it more holistically with a number of GLAD-2 principles or factors, they determine what is the most appropriate path moving forward. It may include incarceration, it may not. The length may be a factor, or the reintegration and rehabilitation are factors. What this legislation is effectively saying is, too bad, 718 too. What Minister Nicholson says when he says, I don't care if they went through residential school, we're not giving breaks to sexual offenders, is that we don't care what the current legislation says, but we don't have the guts, and I'm being friendly there, the guts to revoke this provision because we know the chaos that would ensue. We know the constitutional challenges that would arise. So taking that judicial discretion away is going to be problematic. Giving it to the Crown and the police to decide when they're laying a charge or how they're going to prosecute means that you're putting more power into the investigative authorities and less away from what in a fundamentally democratic nation is supposed to be a balance. When you think of, there's the legislature, there's the executive, and there's a judiciary. And so we're stifling the judiciary and being able to be that balance to legislation. That's what this bill is going to have the effect of. I'm not going to go specifically because I'm probably running out of time shortly, but I do want to touch on the parts as they've been laid out by the government. And part 2 includes sentencing reforms that will target sexual offenses against children and serious drug offenses, as well as prevent the use of conditional sentences for serious violent and property crimes. That's taking away the house arrest. It proposes sentencing amendments to the Criminal Code and the Controlled Drugs and Substance Act to ensure that the sentences imposed for child sexual exploitation, serious drug offenses, as well as for other serious violent and property crimes adequately reflect the severity of these crimes. Again, I think I mentioned to you earlier, and the NDP critic actually mentioned it in his address when this was introduced. 6 pot plants means that you're now convicted of trafficking and that there's a mandatory minimum. Is that adequate? Does that adequately reflect the severity of these crimes? Something to think about. Part 3 includes post-sentencing reforms to increase offender accountability, eliminate pardons for serious crimes. So now not only are we going to increase incarceration, we're going to say you need to wait longer before we're going to pardon you. I remember when I was in law school, one of these great debates we used to have in our first year of law school was when a person has served their crime or done their time, is that the end of it? When their sentence is complete, they've served their time, they're done, right? They owe their debt to society. All of the sentencing principles such as deterrence and rehabilitation, those should have all been met, right? Does the person get to walk away? Well, apparently not under Omnibus. You can serve your time, and if you're Aboriginal, you're likely going to serve it to the warrant expiry, not just, 1 or 2/3. So, and then, by the way, you're going to hold that record longer because we don't think our current guidelines are strong enough. Sentence calculations will be changed, adding new offenses recently enacted by other legislation. So there's going to be new offenses that will increase offender accountability, added to that under Part 3. Part 4 includes reforms to better protect Canadians from violent young offenders dealing with violent and repeat young offenders. I have huge problems with this. I think part of my problem with this is that from an Anishinaabe perspective, we look at our youth and our children as our teachers. They have a big role, and we also have this concept of non-interference, allowing our children a level of independence that if it doesn't harm someone else, so that they can learn and grow and develop and become beings, human beings in their own right, the animals that walk on 2 feet. But we're going to put stricter legislation. Well, when the YCGA came in, the Youth Justice Act came in to replace the YOA, the Young Offenders Act. Part of it was this fundamental change in sentencing principles. The need to recognize that putting our kids into closed custody wasn't helping. It wasn't making them rehabilitate. It wasn't putting them back out in the world ready. So the YCGA was this approach to include incremental sentences. So first you get an extrajudicial measure. And then you get a warning from the judge. And then you might get some other probation and stuff before you ended up in either what was previously called open or closed custody. What they're now proposing to do is get rid of a lot of those things. What we're proposing to do is criminalize our young people. And when people are youthful in their adolescence years, when they're learning, when they make mistakes, part of fundamental Anishinaabe beliefs are mistakes are not just bad things, they're also things that teach you how to do things better. And I'm not saying that there aren't some serious crimes that young people will commit that might require a level of judicial sanction, but I think it's crazy that we're going to increase sentencing and make things harsher for young people rather than trying to rehabilitate them. Because if we can't rehabilitate them when they're most formative, where is their future? It's going to be in the super jail. Making it easier to detain youth charged with serious offenses pending trial. So, your basic rights around bail and such. Ensuring that prosecutors consider seeking adult sentences for the most serious offenses, prohibiting youth under the age of 18 from serving a sentence in an adult facility, and requiring police to keep records of extrajudicial measures. So under the YCJ, the police can do a number of things before a matter even goes to court. They can give the kid a stern warning, they can go and talk to the parent, they can enter into different processes. These are known as extrajudicial measures. And so what this legislation is going to propose to do is that they require the police to keep records. If the whole point of extrajudicial measures is that the court doesn't need to become involved, why do records now have to be put into the court? Because the individual or that serious, violent, repeat young offender isn't rehabilitating? It's concerning. It sets particularly Aboriginal youth up for danger and danger of becoming institutionalized throughout their lives. So, is there enough opposition? Well, the strong mandate of the Conservative government is going to push this legislation through. It was a promise they made prior to being elected. They're going to push it through whether there's opposition or not. So where does that leave us? What's the reality? One thing that Mr. Joe Comartin said, this is the opposition justice critic, the NDP one, it's when this bill was introduced, he said this is a historic day in Canada. It's historic because we have had a government for the last 5 years that has attempted to reverse the approach to the criminal justice system that we have taken in our country for the better part of 40 years. Canada internationally has been seen as a leader in relation to their criminal code and the methods of what they're trying to do in terms of not incarcerating, but finding fit, appropriate sentences. Okay? When the watershed legislation changed in 1996 through 1998, and that's when that one provision, 718(2)E, came into place, it was known that there had been a marked change, that the approach was to not incarcerate people so much because it wasn't being effective. And now, a little more than a decade later, we're finding ourselves taking a 50-year leap back. In the United States, the war on drugs died. What happened in the United States? The legislature tried to deal with the problem of drug trafficking. Starting about 2.5 years ago, the American began to repeal legislation that had mandatory minimums. Why would they do that? Oh, that's right, their jails were filling up with people to the extent that they couldn't house the real serious offenders. The super jails were getting too full. They were costing billions and billions of dollars and going bankrupt. It was simply that they were going bankrupt in terms of keeping that many people in jail. So what happens is you have a bunch of people that become incarcerated for varying crimes, and people should then be released based on that, right? They're not, though. When you're so overcapacitated that you're releasing people who maybe should or shouldn't be incarcerated. I would never advocate for incarceration, but just as an example, someone who should be incarcerated for a longer duration because of serious offense, such as a serial killer who owns a pig farm, is going to be released serving a lesser sentence. That wasn't what the laws said in California and New York State and Florida when they were first passed. But many years later, that's the reality. The law, the mandatory minimums, have caused problems. It's caused financial problems, it's caused social problems, it's caused a correctional mentality of the super jail. So why is Canada taking these steps backwards to be tougher on crime when we're now at one of the lowest rates of crime we've ever been at. So in the context of like learning more, and I know I had a moment there where I said, what do we do now? They're gonna pass it anyways. What do we do now if they're gonna pass it anyways, right? There's gonna need to be a lot of constitutional challenges. People are gonna have to fight extra hard for their rights and any of the law that's already been in place. So when judges have made law around a person's constitutional right to liberty, or when they've made law around things like Ladue, people are gonna have to fight a lot harder for their rights. It's gonna mean a lot more custody time and sitting and waiting in jail though, for a little bit of legal release. What can I encourage you to do? Learn more. I know that it's gonna be hard to copy these down, but if you actually go on to Google and type in a Google site,